A common credit repair scam fails. Hi, this is Consumer Protection Attorney Bill Clanton, and today we're talking about the Chuluunbat case out of the Seventh Circuit. Came down in it was argued July of 2021. Argued April of 2021, decided July of 2021. This is an interesting case. It covers a very common scam or advice or whatever you want to call it, bad advice that is given I've seen on YouTube, on TikTok, other social media outlets, on people who are offering credit repair advice. The idea is, I'll give you the idea, I'll talk about what the court talks about, and then talk about some alternatives that are suggested by the court, to handle the same situation. So the idea is that you dispute credit card debt that's being reported on your credit report is in default by debt collectors. You dispute it by saying that they can't prove they own it. You say that they have to prove the validity of the debt. You're not saying that the amount is wrong. You're not saying that you don't own it. You're saying that they can't prove that they own it. And then you put the burden on Experian or TransUnion or Equifax to get the proof of the assignment of the debt from the credit card company to the debt collector. And that doesn't work. In this case, talks about why. So let's take a look at it. That's exactly what, there's a bunch of plaintiffs, there's a bunch of similar claims that were pending. They got consolidated for appeal. And each one of these cases was turned down by the trial court, and this got appealed to the Seventh Circuit Court of Appeals. So this is a step below the Supreme Court and a step above the federal district courts, the federal circuit courts. The Seventh Circuit is based out of Chicago and covers, I forget exactly the states it covers, but certainly Illinois and Wisconsin and some other, at least one or two other states up there. So, so what happened is there were, like I said, 1, 2, 3, 4, 5, 6, at least 6 of these lawsuits that got decided by the district courts and got consolidated for appeal. And the common facts are that they disputed these debts, that the creditors could not prove that they owned the debts. And so the creditors all confirmed the reports were correct and they owned the plaintiff's debts in response to the disputes. So they disputed. TransUnion, Equifax, Experian forwarded those disputes to the debt collectors. The debt collectors all responded that they owned the plaintiff's debts. The creditors did not, however, produce the original sale or assignment agreement in any case. After receiving this confirmation, the consumer reporting agencies informed the plaintiffs that no further steps would be taken to investigate. That was the end of their investigation on these types of disputes. So the court refers to the plaintiffs then sued the Experian, Equifax, and TransUnion, and the court cited the Deanan case, which held that a consumer's defense to a debt is a legal question to resolve in an action against the creditor, but not a duty imposed on the consumer reporting agency by the FCRA. Each court agreed the plaintiffs did not plead the type of inaccuracies that a consumer reporting agency can correct. As to 2 of the plaintiffs, the court said whether creditors owned the debt was a question of law and outside the credit bureau's ability to dispute or to resolve. In another court, decided it was a mixed question of fact and law. And the third, and for the plaintiffs and the district court said that focused on the institutional competency of the consumer reporting agencies to resolve these types of claims. Whether creditors own the debts was a question outside the competencies of consumer reporting agencies, the court decided. And that the inaccuracy to correct, and it's not the type of inaccuracy that can be corrected through a reinvestigation or through a dispute. The court goes on to say that the Fair Credit Reporting Act imposes certain duties on furnishers of information. They have to make sure that it is have reasonable procedures to assure the maximum possible accuracy. And the plaintiffs argue whether the creditors were assigned and now own the debts is a factual question within the statutory obligations of the FCRA. And that's what, it makes sense, right? Does the creditor own the debt? Is that a question of fact or law? Well, yeah, I mean, do they own the debt? They should be able to say, yes, they own the debt. But when it involves attacking the proof that they own the debt, that's a deeper question than do they just own the debt. Okay, by the plaintiff's account, the court says, all that the consumer reporting agencies need to ascertain is whether a purchase and sale agreement exists for each of the plaintiff's debts. They see requesting the purchase and sale agreements as a straightforward factual inquiry. Well, then the court says the paradigm example of a legal dispute is when a consumer argues that although his debt exists and is reported in the right amount, it is invalid due to a violation of law. So, and they go back to the Deenan case, where in Deenan, the plaintiff did not dispute whether the debt existed or its amount, but instead contended he was not required to pay the debt because it was legally invalid. Well, that's a question of law, not whether the debt exists, but that it's legally invalid. And then the DeAndrade case. We've made a video about DeAndrade, about the windows, the mortgage on the windows. There was similarly a legal question there. So the court contrasts that with factual disputes. Factual disputes is factual inaccuracies include amounts the consumer owes, what day a consumer opened an account, or incurred a payment. Taking notice of a previously resolved legal dispute involves some knowledge. Now here's kind of entering a little bit of the gray area. According to the court, taking notice of a previously resolved legal dispute involves some knowledge of the legal impact of court decisions, but does not require the consumer reporting agency to make any legal determinations about the underlying claim. And this is kind of how bankruptcies are handled by the bureaus. If you file a bankruptcy, the bureaus have to know that there's a legal impact to filing a bankruptcy, but they don't have to know all the minutiae of it. Okay, so these examples, the court says, show that the central question is whether the alleged inaccuracy turns on applying the law to facts or simply examining the facts alone. Consumer reporting agencies are competent to make factual determinations, but do not reach legal conclusions like courts do. Okay, so whether a debt was assigned absent a previous decision by a tribunal, that is, a question that requires a legal determination, is placing it outside the competency of a consumer reporting agency. The plaintiffs in these cases do not contest their debt's existence or the debts are in improper amounts. Rather, they make a pure challenge as to the debt's legal validity. The plaintiffs here question the relationship of different parties to these debts, which is a task for the court. So, and it goes on to say, the assignment agreement, it determines this. Contrary to the plaintiff's assertions, any investigation into whether creditors were assigned the debts involves more than just determining if an assignment agreement exists. It also involves interpreting the legal validity of that assignment agreement. So the question the plaintiffs are asking the bureaus to resolve is larger than whether an agreement just exists. They're asking about the validity of that agreement. And this is, like I said, a common credit repair bad advice. Disputing the validity of the debt because they can't prove the assignment. You'll see people on YouTube and on TikTok saying they can't prove the assignment, attack the assignment, but the bureaus can't say whether an assignment is valid or not. They rely on the creditor. The creditor says, yes, it's valid. That's the end. You can't attack a debt as invalid based on an assignment through a credit bureau. You can do that in a court of law, but not through a credit bureau. Okay, so sometimes when a consumer claims a debt is not owed, it presents a factual question. This could occur if the consumer argues a furnisher has factually misidentified him. Say a wrong social security number. It could be the result of identity theft. It could be a mixed file. It could be any number of things. But consumer reporting agencies will not be required to investigate such claims. The investigation primarily requires them to make a legal judgment or is outside their competency. If the plaintiffs presented the court judgments to the consumer reporting agency. If the plaintiff is presenting court judgment, so if you have a judgment that says final judgment or dismissal with prejudice, you can send that to a consumer reporting agency, and they will have to remove it from your credit report as not owed, or a take nothing judgment. If you get take nothing judgment against a debt collector that's suing you, then you can send that to the credit bureaus, and they'll have to change their reporting. But that's a legal determination made by a court that a credit bureau has to then respect. But attacking the assignment through the bureaus is a failing advice. It's a failing practice, and that's what this court says. It wraps up the opinion by saying, what these plaintiffs cannot do, though, is place the burden for determining whether their debts were validly assigned onto the consumer reporting agencies where it does not belong. Okay, they say also in here that another avenue for the plaintiffs, which allows consumers to make notations, making notations of dispute in your accounts, disputing it with the creditor, engaging with the creditor, with a third-party debt collector, is what they advise to do. Listen, be careful out there. You can send disputes to the credit bureaus, but they are big and powerful, and lots of times decisions go in their ways. And it's important to highlight the dangers of trying to do credit repair yourself. It's a minefield, and we don't do credit repair. But if you've got an error on your credit report, give us a call. If we can't help you, we can put you in the hands of somebody who can, who's a very competent attorney and would know better than to file a case like this and get a good opinion for the bureaus. So thanks for watching this video. If you can share this with one other person, give them some advice that would help them, then I would sure appreciate that. And I would also appreciate if you subscribe to this channel. Thank you.